In 68 years after Martin Luther King pleaded, "Give us the ballot, and we will no longer have to worry the federal government about our basic rights," the beating heart of the Voting Rights Act was the subject of debate today in the nation's highest court. And the justices appear to be on the verge of a decision that could have enormous consequences for the upcoming midterms and for our very democracy. At issue today, Louisiana's congressional map adopted last year with 2 majority black districts in order to comply with curbs on racial gerrymandering put in place by Section 2 of the Voting Rights Act. The justices today are being asked whether race can be considered a factor in drawing maps. Here's how Janai Nelson, the lawyer defending Louisiana's congressional map, describes the stakes.
Were Section 2 to cease to operate in the way that you just described, what could happen? What would the results on the ground be?
I think the results would be pretty catastrophic. If we take Louisiana as one example, every congressional member who is black was elected from a VRA opportunity district. We only have the diversity that we see across the South, for example, because of litigation that forced the creation of opportunity districts under the Voting Rights Act. Every justice in Louisiana has been elected through a VRA opportunity district, and nearly all legislative representatives.
The New York Times reports this, quote, "Without Section 2, Republicans could eliminate upward of a dozen Democratic-held districts across the South. The plaintiffs are seeking to overturn the map and potentially bring down Section 2, argued that creating majority black districts amounts to discrimination against white voters." Here's what Justice Sonia Sotomayor said about that.
My humble point is that the government has no business telling citizens in which districts they may live or what voting power they may
exercise. But it's not doing that, counsel. The 6 plaintiffs in this case are white plaintiffs who live in a district with black voters. So no one's keeping them out of that district. No one's stopping them from participating in the voting process. No one is stopping them from trying to run candidates or support candidates that reflect their views.
An attorney for the Trump administration called the voting map a, quote, "reverse partisan gerrymander," saying that white Democrats in red states do not get maps drawn, allowing them to elect Democratic candidates. But the logic of that ignores the history. It ignores why the Voting Rights Act exists, why it was put in place in the first place. And it ignores the impact that any decision weakening or striking down parts of the Voting Rights Act will have. Once again, here's Janai Nelson.
My opponents here would like to make this a partisan issue because they believe the case law will enable their case to prevail, but it does not. This is about race. Section 2 and the Voting Rights Act is laser focused on eliminating racial discrimination from our electoral process, regardless of party. And if we look at many of the black Congress people who were elected, they came out of Section 2 opportunity districts. They don't have to be majority minority districts. Many of them are crossover districts. And so if we remove Section 2, we also recognize that there will likely be a resurgence of discrimination because Section 2 plays a deterrent effect.
That is where we begin today with some of our favorite experts and friends. MSNBC senior contributing editor Michelle Norris is here. Also joining us, voting rights attorney, founder of Democracy Docket, Mark Elias. Mark Elias, I ask you the same question that we started with here, the stakes of today's arguments and case.
Yeah, the stakes are enormous. I mean, the fact is that the Supreme Court of the United States heard a case today that, to be clear, no one brought to them. The case that was brought to them out of Louisiana was argued last term, did not challenge the underlying constitutionality of the Voting Rights Act. We went through briefing, we went through oral argument, we all waited for a decision by the end of last June in the case that was actually brought by the plaintiffs and the petitioners in that case. Instead, what happened is the Supreme Court decided that it wanted to hear a different case. So it ordered the parties to brief and re-argue a broader question, the question of whether or not Section 2 of the Voting Rights Act remains constitutional, and if so, how does it get severely limited? And that was what the argument was about today. Like, make no mistake, I never predict with certainty what the outcome of cases will be. You never know what the dynamics are among the justices, but this was a case that was set up to do immense damage to the crown jewel of American democracy, which is what Democrats and Republicans have called the Voting Rights Act for decades. And that is where this court today signaled it wants to go. Again, understanding it may not get there. It may back away from it. It may, at the last minute, decide not to do this. But everyone needs to be clear-eyed that that is what the court is poised to do. And if it does so, it will have dramatically detrimental effect to Black and Hispanic and other minority voting rights. And it will also potentially tilt the balance of power going into the 2026 midterm elections.
Mark Elias, just refresh my memory on the history of the lack of partisanship. Is George W. Bush the last Republican president to renew the Voting Rights Act? I believe I remember an event in the Roosevelt Room where that is renewed, and then it becomes a political piñata in the last 2 decades. Is that, I mean, just take me through the political side, not the legal side of this debate.
Sure. So the Voting Rights Act gets enacted in 1965 with bipartisan support. Republicans and Democrats both voted to enact the Voting Rights Act. It was renewed under Republican presidents. It was renewed by Ronald Reagan in 1982. And in fact, not only was it renewed under Ronald Reagan in 1982 with, again, overwhelming bipartisan support, it was actually expanded. The provision that is now being attacked, this Section 2 of the Voting Rights Act, which prohibits both discrimination in voting with intent, but also with the effects of discriminating against voters, that was put into law in 1982 under Ronald Reagan. Again, wide bipartisan support. It was, as you point out, reauthorized again in 2006 under George W. Bush, passed the Senate 98-0. There were only 33 no votes against it in the House. It was sponsored by the business community. Walmart's president and CEO pushed for reauthorization of the Voting Rights Act. And it is only in the age of Donald Trump and in his first term and now, today, in which it has become a party line issue in which no Republican will support reauthorization of the Voting Rights Act.
Michelle, I thought that I think it's important context that legally and politically, right now it's another thing pulling our country apart. Through its existence, it has been one of the few things that brought us together, that Democrats and Republicans agreed on, that had unanimous votes in the Senate, and 22 was, even in those times, a very small number of dissenters in the House. And here we are now. With that larger frame, tell me how you watch today's arguments.
I want to pick up on something that Mark mentioned, intent. There was an intense argument over intent in the arguments today, and this notion that pernicious outcome, has to be based on someone intending discrimination, or that rather something could happen because of a series of accidental decisions, and that would lead to something pernicious, but it wasn't about intent. I think we have to look at intent here, particularly when we're talking about voting access, and put it in context, because it's been widely reported that Donald Trump has been pressuring states to redraw their electoral maps as Democrats work hard to take over the House. And so you could look at this and you could ask, is this really about, the case that was brought by a group of people who self-identify as non-Black voters? Is this really about creating a just and fair, colorblind system to create equal access to the ballot, or is it really about the preservation of power? And I think we know the answer to that. And the question is whether the Supreme Court will allow itself to be used in, is part of that effort to try to maintain power, not just by Donald Trump, but by Republican legislatures all around the country.
It's so important to not isolate this issue and sort of dissect it as a tree, but to continue to stare at the forest. And I want to play a little bit of what Justice Ketanji Brown Jackson said, sort of in defense of Section 2.
If I'm right that Section 2 is about identifying the problem and then requiring some remedy, I don't understand why your answer to Justice Kagan's question about is this a compelling state interest is no. The answer is obviously yes, that you have an interest in remedying the effects of racial discrimination that we identify using this tool. Whether you go too far in your remedy is another issue, right?
Such stark statements today and questions coming from the justices, Michelle.
Well, we should also remember, in putting this in context, Nicole, that Justice Roberts has really, has been fighting against the Voting Rights Act and Section 2 in particular for a very long time, back to when he was a baby lawyer working in the Reagan administration and, working for Rehnquist. And one of the things that comes up again and again from him and from people who are arguing against this is that the way to end discrimination, he actually said this in a case that involved an effort to desegregate a school system, the way to end discrimination is to actually end discrimination. And what they're basically doing is conflating the remedy with the discrimination that called for the remedy in the first place, and saying that in order to remedy these issues, that actually becomes a form of discrimination. And looking at the 14th Amendment in the purest sense that the government cannot use race in any way in making any kind of decisions. And what that does is it disenfranchises a large number of people. And when you ask about context, the other thing to remember is the fact that so many people of color are concentrated in these districts is a result of discrimination in itself there, because the reason that they're so concentrated is because they couldn't live other places. They didn't have access to capital. They didn't have access to mortgages. And so you create a system over time based on discrimination where you've got large groups of people who are concentrated, and then you create a system that doesn't allow them to have access to the vote because you either have them concentrated in so small districts that they're not able to elect a large number of representatives, or you crack and frack their voting blocks and you distribute them in places where then they aren't able to vote in their best interest. And at the same time, arguing that this has nothing to do with race on its face just doesn't make sense.